Hello viewers and listeners, thank you very much for making time once more with BWF Solicitors Community and the Law Program. Today we are looking at one of the critical tests that ought to be met when a parent seeks to bring a child from abroad to the UK. This is found under paragraph 297 IF of the immigration rules, especially when the parent is a British citizen or has settlement status. So we are looking at serious and compelling family considerations that makes the child's exclusion from the UK undesirable, and arrangement that the parent who is based in the UK has put in place to make the child's life manageable when the child joins the parent in the UK. So we look at what constitute serious consideration that ought to be taken into account. Serious is anything that affects the child's welfare. It is a harm test. And here we are looking at abuse. We're looking at neglect. So financial abuse, physical abuse, emotional abuse, and all forms of abuse. How do we know the child is being abused? It might be that the parent or the carer who is taking care of the child is not playing the role that a father or a mother will be playing. So the child has not been eating properly. The child has not been clothed or dressed properly. Even though the parent based in abroad sent all the necessary support, the care is not good enough. The child is left to his or her own faith. The child may even be sexually abused by the person they live with or by other people just because there's no adult who properly takes care of this child. This is where things become serious and affect the child's welfare. For this reason, we are looking to make an application so that the child can be protected and the welfare can be maintained. We are looking at what is in the child's best interest. So the best interest test ought to be followed under Section 55 of the Borders, Citizenship and Immigration Act 2009. And this is a welfare assessment based on what is best in the interest of the child under the various considerations that we are having, and that consideration is paramount. We're also looking at case law, where it says that it is not about the fact that a child is being moved to another country so that there could be better education, better life, and so on and so forth. But we are looking at something that is so compelling that without the child being brought to join the parent who is abroad or in the UK, the child welfare will be affected. And this is fact sensitive in that each case will be assessed on its own merit. So what evidence do you have to put together? If the child is living with a non-family member, the non-family member has to show that they are no longer able to take care of the child, and this has to be in writing. If the child is being abused by family members or whoever, there should be a police report to show that the child is going through abuse. Also, social welfare report to show that the child is going through abuse. It is not enough to claim that the child is going through serious circumstances or challenges, but it is always the case that the evidence you put together makes it reasonable for the child to be allowed to enter the UK. The case of NA Bangladesh 2021 says that the test is that of reasonableness, and therefore, in all circumstances, the evidence should point towards the fact that it is compelling, it is reasonable, and desirable for the child to be allowed entry clearance to enter the UK. This is the responsibility of the parent who is making the application. It is important, therefore, that to be able to meet this high threshold of the immigration rule, You take your time to plan the application process so that you have all the things in place. So that even if the caseworker is not able to agree with you, when you go to the appeal, the tribunal judge will understand that in the interest of the child and the welfare of the child, and the fact that there's the need to mitigate any harm, be it existing harm or imminent harm, the child's paramount interest will be for him or her to join the parent who is in the UK. This is the test under paragraph 2971F of the Immigration Rules. Thank you for listening.